How private parties abuse franchises to compel you to contract with the government. Since all franchises are contracts or agreements that acquire the force of law only by your express or implied consent, then any of the following activities represent an attempt to contract with the government grantor of the franchise. 1. Using a government form available only to franchisees. 2. Invoking or claiming any status within a government franchise. Such statuses include the following statutory statuses: U.S. citizen, U.S. resident, U.S. person, or taxpayer under the Internal Revenue Code. Employee under 26 U.S. Code 3401C. Employer under 26 U.S. Code 3401D. Spouse under the Family Code of your state. Driver under the Vehicle Code of your state. Buyer or seller under the FIRPTA provisions of the IRC as described in income taxation of real estate sales. 3. Invoking or claiming any right or privilege within a government franchise. For instance, receiving or being eligible to receive Social Security benefits. Invoking a graduated and thereby reduced rather than fixed rate of tax under 26 U.S. Code 1. Invoking earned income credits under 26 U.S. Code 32. Invoking trade or business deductions available only to those lawfully engaged in a public office within the U.S. and not state government under 26 U.S. Code 162. As a risk reduction strategy, the legal departments of most companies will insist that all the people they deal with agree or consent to be in a privileged state by insisting that they meet one of the above criteria. This is their technique, essentially, of 1. Producing evidence to defend themselves from damages they cause to their clients by their illegal honoring of a levy or lien against a non-taxpayer. 2. Producing evidence that you consented to be privileged and therefore do not have standing in court to claim an injury against them. 3. Preventing themselves from becoming the targets for IEDS enforcement because they might be misconstrued as violating provisions within the IRC trade or business franchise agreement. Keenly aware of the above, private companies such as escrow companies, financial service companies, businesses, and employers typically will tactically compel you to contract with the government using the following means. 1. Invoking statutory franchise statuses as their application forms for services or the contracts, real estate sale contracts, for instance, that are the output of their services. 2. Saying they won't do business with you or provide the service you contract with them for unless you invoke a statutory franchise status. You agree not to remove references to statutory statuses on their forms or output of their services. Submit knowingly false withholding forms that misrepresent your status as a statutory individual, non-resident alien individual, or taxpayer. 3. Secretly filing reports that connect you franchise statuses without your knowledge as retribution for insisting that they not misrepresent your status in their records. Such records include currency transactions report and suspicious activity report filed with the finances of the Department of Treasury. As an example of the above, here is the provision that a real estate escrow company put within a sales contract that forces the seller to be subject to FIRPTA who would not otherwise be as a precondition of the sale. Any astute reader will ensure that such provisions are not in their land sale contract. This is an example of private parties compelling you into a privileged state and therefore destroying your constitutional rights. Figure 1. FIRPTA provisions within land sale contract. 130 I edit as an FIRPTA reporting. Seller agrees to comply with I edit as reporting requirements if applicable. Seller agrees to complete, sign, and deliver to escrow company a certificate indicating whether seller is a foreign person or a non-resident alien, pursuant to the Foreign Investment in Real Property Tax Act. Buyer and seller acknowledge that the seller is a foreign person. The buyer must withhold a tax equal to 10% of the purchase price unless an exemption applies. The following provision strategies should be pointed out in response to such criminal tactics by escrow companies. 1. FIRPTA only pertains to United States properties, which are properties physically located in a territory or possession or area in which the United States government has outright or equity ownership of the entire property or a portion thereof. 2. An exclusively private party who is not managing public property does not have any status under the IRC. All individuals within the Internal Revenue Code are public officers or instrumentalities within the U.S. government. 3. By including the above provisions within a land sale contract against an otherwise exclusively private party who is not a public officer taxpayer, they are acting as the equivalent employment recruiters for the national government, and doing so illegally and in violation of 18 U.S. Code 912, 201, 208, and 210. 4. One cannot, by exercising their rights to contract with an otherwise private party, lawfully do any of the following without criminally impersonating public officers within the U.S. government. Invoke any franchise status, including individual, non-resident, alien, individual, taxpayer, person, etc. Invoke any privilege, payment, or benefit within a franchise. It is illegal for the Gov to pay benefits to exclusively private parties or to abuse their taxing power to redistribute wealth or benefits among otherwise private parties. 5. An exclusively private party not acting as a public officer within the U.S. government at the time of executing the above transaction would be committing perjury under penalty of perjury to sign any form that connects them to any franchise status, benefit, or legal eligibility for benefit in violation of 18 U.S. Code 1542, 18 U.S. Code 1001, and 18 U.S. Code 1621, if the document or any of its attachments require a perjury statement. Yeah, that's why they can lock up homeless people. 6. All attempts by third parties you do business with that encourage you to put knowingly false statements on the application for their services to the output of their services constitute a conspiracy to commit perjury. Yep. 7. It is very important to define all terms on all forms you fill out as being other than the terms used in any state or Fed law. The contract provisions above, for instance, did not precisely define all terms, thus delegating undue discretion to both the clerk receiving the form or the judge or the jury reviewing the form in future legal proceedings to define the term in a way that needlessly benefits the government at your expense. Yeah. The following form prevents such as define, determine, such abuse of language in the context of taxation as an excellent and highly recommended way to prevent such abuses. 8. All forms signed under penalty of perjury become testimony of a witness. It is a crime in violation of 18 U.S. Code 1512 and state law to tamper with, advise, or threaten such a witness to change or alter their testimony, and especially to change it to something that they know is false. That means that they can't threaten you, withhold service from you, or punish you in any way because they don't like what you put on their forms or don't like the attachments you mandate to their forms. Exactly. 9. To protect oneself from such stealthful attempts by third parties to recruit you into a public office in the government, you should ensure that the crimes and misrepresentation described herein are thoroughly and completely documented in writing, in the administrative record of the party who attempted it, and in your own records, and that such documentation is served upon them with the following form, providing proof that you formally did so. This will produce the evidence you will later need to prosecute the perpetrator of these injuries. They will try to avoid this by talking with you on the phone or in person, but you should hang up on the phone and tell them you want your responses and all communication in writing, signed by a specific person in the company so that they cannot avoid producing evidence admissible in court of their own wrongdoings. That part. The greatest irony of all is that governments are created to protect your rights, to privately contract, and yet every opportunity where you could invoke their authority to protect the exercise of that right turns into an opportunity to force you to contract with them under their franchises. They, in effect, through deceptive words of art, attempt to insert themselves as parties into every contract and then use that relationship to steal from and enslave both parties to the contract to themselves and extract as much wealth from the transaction as they want without contributing anything to the transaction that either party regards as having any value at all. That's totally evil. The right to contract, if it is a right at all, certainly includes the right to contract the government out of the relationship between the parties. The reason for this is found in the legal definition of property, the essence of which is right to exclude all others from using or benefiting from said property. Below is how the U.S. Supreme Court describes the right of the Fed government to interfere with, rather than protect your private rights to contract. Independent of these views, there are many considerations which lead to the conclusion that the power to impair contracts by direct action to that end does not exist with the general government. In the first place, one of the objects of the Constitution expressed in its preamble was the establishment of justice, and what that means in its relations to contracts is not left, as was justly said by the late Chief Justice in Hebrew vs. Grawell, to interference or in conjunction. As he observes, at the time the Constitution was undergoing discussion in the Convention, the Congress of the Confederation was engaged in framing the ordinance for the government of the Northwestern Territory, in which certain articles of the compact were established between the people of the original states and the people of the territory. For the purpose, as expressed in the instrument, of extending the fundamental principles of civil and religious liberty upon which the states, their laws, and constitutions were erected. By that ordinance, it was declared that in the just preservation of rights and property, no law ought ever to be made or have force in the said territory that shall in any manner interfere with or affect private contracts or engagements bona fide and without fraud previously formed. The same provision as the Chief Justice found more condensed expression in the prohibition upon the states against impairing the obligation of contracts, which has ever been recognized as an efficient safeguard against injustice, and though the prohibition is not applied in terms to the government of the United States, he expressed the opinion, speaking for himself and the majority of the court at the time, that it was clear that those who framed and those who adopted the Constitution intended that the spirit of this prohibition should pervade the entire body of the legislation, and that the justice which the Constitution was ordained to establish was not thought by them to be compatible with the legislation of an opposite tendency. Similar views are found expressed in the opinions of other judges of this court, which was here in 1798. Mr. Justice Chase said that there were acts which the Fed and state legislators could not do without exceeding their authority, and among them he mentioned a law which punished a citizen for an innocent act, a law that destroyed or impaired the lawful private contracts of citizens, a law that made a man judge in his own case, and a law that took the property from A and gave it to B. It is against all reason and justice. He added, for a people to entrust a legislator with such powers, and therefore it cannot be presumed that they have done it. They may commend what is right and prohibit what is wrong, but they cannot change innocence into guilt, or punish innocence as a crime, or violate the right of an innocent lawful private contract or the right of private property. To maintain that a Fed or state legislator possesses such powers, if they had not been expressly restrained, would, in my opinion, be a political hearsay altogether, and admissible in all free republican governments. In Ogden versus Saunders, which was before this court in 1827, Mr. Justice Thompson, referring to the clauses of the Constitution prohibiting the state from passing a bill of attainder, an ex post facto law, or a law impairing the obligation of contracts, said, neither provisions can strictly be considered as introducing any new principle, but only for greater security and safety to incorporate it into this charter provisions admitted by all to be among the first principles of our government. No state court would, I presume, sanction and enforce an ex post facto law if no such prohibition was contained in the Constitution of the United States. So neither would retrospective laws taking away vested rights be enforced. Such laws are repugnant to those fundamental principles upon which every just system of laws is founded. In the Federalist, Mr. Madison declared that laws impairing the obligation of contracts were contrary to the first principles of the social compact and to every principle of sound legislation. And in the Dartmouth College case, Mr. Webster contended the acts which were there held to impair the obligation of contracts were not the exercise of a power properly legislative, as their object and effective was to take away vested rights. To justify the taking away of vested rights, he said, there must be a forfeiture to adjudge upon and declare which is the proper providence of the judiciary. Surely the Constitution would have failed to establish justice had it allowed the exercise of such a dangerous power to the Congress of the United States. In the second place, legislation impairing the obligation of contracts impinges upon the provisions of the Constitution, which declares that no one shall be deprived of his property without due process of law, and property and large portions of the wealth of the country exist in that form. Whatever impairs their value upon the contract, forbidding its enforcement or transfer or otherwise restricting its use, the owner is as much deprived of his property without due process of law as if the contract were impounded, or the value it represents were in terms wholly or partially confiscated. How franchises are abused as snares by corrupt rulers to trap and enslave the innocent and the ignorant and undermine the constitutional separation of powers. Franchises are the method of choice. Franchises, your all caps letter name, are the method of choice in a free society by which the innocent, the sinful, or the ignorant are cunningly snared, abused, and enslaved to the whims of civil rulers lawfully. The hand of the diligent will rule, but the lazy man will be put to forced labor, slavery. Since participation is at least theoretically consensual and contractual, then no one who participates can claim an injury cognizable in a real Article 3 court under the common law. Volonte non fit injuria. He who consents cannot receive an injury. Consensus talat heterum. Consent removes or obviates a mistake. Malayas esta amania mata patapika talamanat santayya. It is better to suffer every wrong or ill than to consent to it. Nemo one cannot complain of having been deceived when he knew the fact and gave his consent. Brower's Maxims of Law, 1856. Everything the government gives you or promises you, in which is commonly called a benefit, is in fact a snare used to entice you into servitude to them, because everything they give you will always have strings attached. The snare is not physical, but legal and contractual. The mechanism of the snare works as follows. I need some water. Catching wild pigs. A chemistry professor in a large college had some exchange students in the class. One day, while the class was in the lab, the professor noticed one young man, exchange student, who kept rubbing his back and stretching as if his back hurt. The professor asked the young man what was the matter. The student told him he had a bullet lodged in his back. He had been shot while fighting communists in his native country, who were trying to overthrow his country's government and install a new communist government. Sounds about what's going on in this country. In the midst of his story, he looked at the professor and asked a strange question. He asked, "Do you know how to catch wild pigs?" The professor thought it was a joke and asked for the punchline. The young man said that this was no joke. You catch wild pigs by finding a suitable place in the woods and putting corn on the ground. The pigs find it and begin to come every day to eat the free corn. When they are used to coming every day, you put a fence down one side of the place where they are used to coming. When they get used to the fence, they begin to eat the corn again, and you put up another side of the fence. They get used to that and start to eat again. You continue until you have all four sides of the fence up with a gate in the last side. The pigs, who are used to the free corn, start to come through the gate to eat. You slam the gate on them and catch the whole herd. Damn. Suddenly, the wild pigs have lost their freedom. They run around and around inside the fence, but they are caught. Soon they go back to eating the free corn. They are used to it, that they have forgotten how to forage in the woods for themselves, so they accept their captivity. The young man then told the professor that is exactly what he sees happening to America. The government keeps pushing us towards socialism and keeps spreading the free corn out in the form of programs such as supplemental income, tax credit for unearned income, tobacco subsidies, dairy subsidies, payments not to plant crops, welfare, medicine, drugs, etc., while we continually lose our freedoms, just a little at a time. One should always remember there is no such thing as a free lunch. Also, a politician will never provide a service for you cheaper than you can do it yourself. Also, if you see that all of this wonderful government help is a problem confronting the future of democracy in America, you might want to send this on to your friends. If you think the free ride is essential to your way of life, then you will probably delete this email. But Lord help you when the gate slams shut. Keep your eyes on the newly elected politicians who are about to slam that gate on America. Yep. Those who want to trap animals lay out bait and rig the door of the trap to slam shut when the animal grabs the bait. People can be trapped just as easily as animals, and it happens all the time. For the government, this bait is called benefits. You grab or consume this bait by filling out an application such as the SSA form SS5 or IRS form W7 or W9. The courts call this process of grabbing the bait and waiving your sovereign immunity purposeful element. Shit, alright. Fuck, bro. In which the court held the following, which is entirely consistent with the Foreign Sovereign Immunities Act, 28 U.S. Code 1605 et Squire. In this circuit, we analyze specifically jurisdiction according to the three-pronged test. 1. The non-resident dependent must purposely direct his activities or consummate some transactions with the forum or a resident thereof, or perform some act by which he purposely avails himself of the privilege of conducting activities in the forum, thereby invoking the benefits and protections of his laws. 2. The claim must be one which arises out of our or relates to the dependence forum related activities. And 3. The exercise of jurisdiction must comport with fair play and substantial justice, i.e., it must be reasonable. Beyond the point of taking the bait, you are effectively treated as a public officer in the government corporation, or what the U.S. Supreme Court calls the body corporate. Hence, the cage, from a legal perspective, is a corporation, and the animal in the cage is a public officer. Why? Because the government can't lawfully pay public funds to private people. Therefore, you must be assimilated into the government corporation as a public officer and a public person in order to lawfully receive the payments or benefits and in effect become one of them. Good Lord. Yeah. To lay with one hand the power of the government on the property of the citizens, and with the other to bestow it upon favored individuals to aid private enterprises and build up private fortunes, is nonetheless a robbery, because it is done under the forms of the law and it's called taxation. This is not legislation, it is a decree under legislative forms. Nor is it taxation a tax, says Webster Dictionary. It is a rate or sum of money assessed on the person or property of a citizen by government for the use of the nation or state. Taxes are burdens or charges imposed by the legislator upon persons or property to raise money for public purposes. Says very forcibly, I think the common mind has everywhere taken in the understanding that taxes are a public imposition levied by authority of the government for the purpose of carrying on the government and all its machinery and operations, that they are imposed for a public purpose. Why must they assimilate you into the matrix, into the Fed corporation and body corporate called government as a public officer rather than just a private worker or simply a human being? Because the only human beings they can lawfully impose duties upon are those who consent to do so by contract, and all franchises are contracts between the government grantor and the formerly private person. Otherwise, the 13th Amendment prohibits involuntary servitude. It doesn't prohibit voluntary servitude. Like every type of animal trap, the cage or trap is chained to the ground and destroys the mobility, liberty, sovereignty, and freedom of those who eat or who are even eligible to eat the bait. That cage in legal contemplation is portable and can be moved wherever the owner deems proper for their malicious purposes. By examining 26 U.S. Code 7701A9 and 810 and 7701A39 and 7408D, we see that both the cage and the headquarters of Babylon the Great Harlot Fed Corporation, called the United States, is the District of Columbia, or what Mark Twain calls the District of Criminals. Therefore, you are chained to the District of Criminals because you are representing an office in the District of Columbia, the chain or cage. 1. Attaches you to you at the point you consent by filling out the application for the benefit, even if you were threatened and intimidated to fill out the form and thereby render it void. The government will look the other way by deliberately omitting to prosecute the source of the duress because doing so would stop the legal plunder. 2. Consists of the franchise contract that obligates you, the trapped animal, into economic and political servitude to the whims of bureaucrats in the government. This is your half of the consideration that forms the contract. 3. Attaches you to legal status, such as that of a statutory taxpayer. 26 U.S. Code 7701-814. Citizen, 8 U.S. Code 1401. Benefit recipient or Fed personnel. See 5 U.S. Code 5528A12. Only those who have this status can be the object of enforcement of the franchise contract. This status can only be procured through your consent as demonstrated. The first prong is determinative in this case. We have sometimes referred to it in shorthand fashion as the purposeful ailment prong. This prong includes both purposeful ailment and purposeful direction. It may be satisfied by purposeful ailment of the privileges of doing business in this forum, by purposely direction of activities at the forum, or by some combination thereof. We have typically treated purposeful ailment somewhat differently in tort and contract cases. In tort cases, we typically inquire whether a dependent purposely directs his activity at the forum state, applying on effects test that focuses on the forum in which the dependent actions were felt, whether or not the actions themselves occurred within the forum. By contrast, in contract cases, we typically inquire whether a defendant purposely avails itself of the privilege of conducting activities or consummates a transaction in the forum, focusing on activities such as delivering goods or executing a contract. However, this case is neither a tort nor a contract case. Rather, it is a case in which Yahoo argues, based on the First Amendment, that the French courts and term orders are unenforceable by an American court. This is some serious ass shit. I ain't even gonna lie. What time is it? Okay, I got some time. Okay. So the following document proves that the bait or benefit they snare you with, like the bait in real animal traps, was actually worth nothing from a legal standpoint because it created no real right to anything cognizable in a real court of law. So they create fake franchise courts that falsely pretend like it is a benefit and then charge you for the privilege of participating. We documented visually how the government franchise trap works in the following video. None of these concepts ought to be new or unfamiliar to Christians who regularly read the Word of God. The very first city described in the Bible, which was Babylon, was established by a man named Nimrod, who was described as a mighty hunter. What he hunted were men, and he did so by establishing cities full of benefits to lure them into the city from out of their agrarian primitive dwellings. That's crazy. Fuck. To wit, Cush Nimrod, he began to be a mighty one on the earth. He was a mighty hunter before the Lord. Therefore it is said, like Nimrod, the mighty hunter before the Lord in the beginning of his kingdom was Babel, in the land of Shinar. From that land he went to Assyria and built Nineveh and Rezin between Nineveh and Kala. That was the principal city. You can learn the story of Nimrod by listening to the following sermon on our website. The following video very powerfully proves that all present nations and countries are in fact simply people farms for government livestock, where you are the livestock. No, that video was crazy. I saw that shit. It's on YouTube. Y'all gotta watch that shit. I'm gonna post that link. I'm gonna comment that link on my video. The Bible also speaks directly through the prophet Jeremiah about those who devise evil by law as a way to trap and enslave men. The snares they are referring to, at least in the area of government and the legal field, are franchises. The phrase fearing the Lord is defined in Proverbs 8:13 as hating and by implication punishing and preventing violation of Lord's laws such as those described here. Let us now fear the Lord, our Lord, who gives rain, both the former and the latter, in its season. He serves for fuck. Yeah. That's wild, bro. Why is it rain and it's been raining like crazy? The appointed weeks of the harvest. Your iniquities have turned these things away, filling out government forms for benefits, and your sins have withheld good from you. For among my people are found wicked men, the district of criminals who are foreigners, posing as protectors. They lie in wait as one who sets snares. They set a trap. They catch men. As a cage is full of birds. Yo, that's like a bird box. So their houses are full of deceit. In their unserious codes that are not law, but contracts. Therefore, they have become great and grown rich by stealing and spending trillions of dollars from those who were unjustly compelled to participate in government franchises, bruh. All right, I'm about to be done. They have grown fat. They are sleek. Yes, they surpass the deeds of the wicked. They do not plead the cause who plead such a cause, lawyers, the cause of the fatherless or the non-taxpayer, yet they prosper. And the right of the needy or the non-taxpayer they do not defend. Shall I not punish them for these things, says the Lord? Shall I not avenge myself on such a nation as this? An astonishing and horrible thing has been committed in the land. The prophets, pastors in 501c3 privileged churches prophesy falsely, and the priests, judges who preside over a civil religion of socialism that worship the state, rule by their own power, and my people love to have it so. But what will you do in the end? It is interesting to note that our most revered founding fathers understood this concept and warned against engaging in contracts or alliances and, by implication, franchises with any government when they said, my ardent desire is, my aim has been to comply strictly with all our engagements, foreign and domestic, but to keep the United States free from political connections with every other country, to see what they may be independent of all and under the influence of none. In a word, I want an American character, that the powers of Europe may be convinced we act for ourselves and not for others, as public officers. This, in my way judgment, is the only way to be respected abroad and happy at home. Wow. About to enter, fellow citizens, on the exercise of duties which comprehend everything dear and valuable to you, it is proper that you should understand what I deem the essential principles of our government, and consequently those who ought to shape its administration. I will compress them within the narrowest compass. They will bear stating the general principle, but not all its limitations, equal and exact justice to all men of whatever state or persuasion, religious or political, peace, commerce, and honest friendship with all nations, entangling alliance, contracts, treaties, franchises with none. The Bible also disdains contracts, covenants, and franchises with those who are not believers, and especially with foreign governments. Take heed to yourself, lest you make a covenant or mutual agreement, contract, franchise agreement with the inhabitants of the land to which you go, lest it become a snare in the midst of you. Franchises are the main method by which malicious public servants in the government have systematically and surreptitiously corrupted the original purpose of the charitable public trust called government, and usurped it in order to unconstitutionally expand their power and influence, increase the pecuniary benefits of those serving the government, deprive most Americans of equal protection as the foundation of the United States Constitution, exceed their territorial jurisdiction, very deliberately put there for the protection of private rights. Debt and contracts, franchise agreements in this case, are of no particular place. The place of the contract, franchise agreement in this case, governs the act. Brower's Maxims of Law, 1856. 3. Destroy the separation of powers between the state and the Fed government, put there by the Founding Fathers for the protection of our liberties. Franchises are abused to pay bribes to state officials, to disregard and invade the rights of those under their care and protection by condoning the illegal enforcement of Fed statutory civil law and within their borders. 4. Enforce Fed statutory law directly against persons domiciled outside their territorial jurisdiction and state of the Union who do not work for the government, and avoided the requirement for publishing, implementing enforcement regulations and the Fed Register. 5. Introduced and expanded communism and socialism within America, and inducted Americans unwillingly into the service of these causes. Title 50, Chapter 23, Subchapter 4, Section 841, Findings and Declarations of Fact. The Congress finds and declares that the Communist Party of the United States consisting of the IRS, DOJ, and a corrupted Fed judiciary, the Congress finds and declares that the Communist Party of the United States, consisting of the IRS, DOJ, and a corrupted Fed judiciary, although purportedly a political party, is in fact an instrumentality of a conspiracy to overthrow the de jure government of the United States and replace it with a de facto government ruled by the judiciary. It constitutes an authoritarian dictatorship. The IRS, DOJ, and corrupted Fed judiciary, in conclusion, within a constitutional republic, demanding for itself the rights and privileges, including immunity from a prosecution for their wrongdoing in violation of Article 1, Section 9, Clause 8 of the Constitution, accorded to political parties, but denying to all others the liberties, Bill of Rights guaranteed by the Constitution, unlike political parties which involve their policies and programs through public means by the reconciliation of a wide variety of individual views and submit those policies and programs to the electorate at large for approval or disapproval. The policies and programs of the Communist Party are secretly by corrupt judges and the IRS in complete disregard of the tax laws prescribed for it by the foreign leaders of the World Communist Movement. The IRS and Fed Reserve, its members, the Congress, which was terrorized to do IRS bidding recently by the framing of Congressman James Traficant, have no part in determining its goals and are not permitted to voice dissent to party objectivities. Unlike members of political parties, members of the Communist Party are recruited for indoctrination in the public schools by homosexuals, liberals, and socialists, with respect to its objectives and methods, and are organized, instructed, and disciplined by the IRS and corrupt judiciary to carry into action established the assignments given them by their hierarchical chieftains. Unlike political parties, the Communist Party, thanks to a corrupted Fed judiciary, acknowledges no constitutional or statutory limitations upon its conduct or upon that of its members. The Communist Party is relatively small numerically and gives scant indication of capacity ever to attain its end by lawfully political means. The peril inherent in its operation arises not from its numbers, but from its failure to acknowledge any limitation as to the nature of its activities and its dedication to the proposition that the present constitutional government of the United States ultimately must be brought to ruin by any available means, including resort to force and violence or using income taxes. Holding that doctrine, its role as the agency of a hostile foreign power, the Fed Reserve, and the American Bar Association renders its existence a clear, present, and continuing danger to the security of the United States. It is the means whereby individuals are seduced into the service of the World Communist Movement, trained to do its bidding, and directed and controlled in the conspiratorial performance of their revolutionary services. Therefore, the Communist Party should be outlawed. All right, I'm done.